Good morning, everyone. I'm gonna give people a couple minutes to get in because we don't have quorum yet.
I just stepped in. Looks like we don't quite have quorum yet. Is that correct?
Yeah, so we're waiting on one more, and I do have confirmation that at least one person is talking
Good deal.
about another one.
Thanks.
Yep. Can you guys still hear me okay? Let me make sure I just plug the mics down. Okay, looks like we have quorum, so I am going to call this February 25th, 2026 CPRB meeting to order. And I'm going to start with the roll call. First, as you guys can hear, I'm battling a bit of a cold, so excuse my voice, just getting it back. So start the roll, Brandon Brown here. Ken Mildcastle, he has an excused absence for a family issue. Diana Siganovich,
Here.
Dave Gatton,
Here.
Shanoa Miller,
Here.
Edwin Moore,
I'm here.
Glenn Parker III. He also notified me that he's not going to be able to make it for a family issue as well. Billy Sharp and Waverly Willis. I feel like, yeah, I was going to say Waverly. 1 second. Waverly did let us know in advance that he wouldn't be.
Brandon, he just joined.
Oh, we'll let the record reflect that Mr. Willis is here. Although I did, member Willis, I did forget that you had already told us that you wouldn't be able to make it. So if you need to hop off, that's okay. We do have quorum without you. But I do appreciate you hopping on. Okay. So with that, we'll complete the roll. That'll complete the roll, and we'll move on. Just to give people a preview of how we're going to do this meeting, we're going to go into executive session. We'll probably be in there for a while, discussing personnel, employment matters, that kind of thing. Once we're done with that, then we're going to move into some new business, and we're going to start with a discussion or response to the City of Cleveland and U.S. Department of Justice's joint motion to end the consent decree. And then we'll give an update on one of our cases. We won't be discussing the case, but this is just an update. And then we have a scheduled Fourth Amendment training with Dr. Jonathan Whitmer Rich. He's a professor at Cleveland State University College of Law, and he's been gracious enough to come in with us and give us a Fourth Amendment training. I sent around his PowerPoint. We just received it a few minutes ago, so I sent it around probably maybe 15 minutes before the meeting. So I don't think that we necessarily need to review it beforehand, but just in case anyone wants to look at the slides. So he'll be coming in, but he's coming in at 2. So if we finish our other business before he gets in, we'll just move over to old business and discuss some things under there. Administrator search, meeting with the monitoring team, as well as NACO coming up. Man, and so I'm actually hoping that maybe we get through all of that before Dr. Whitmer Rich comes in. So that way, once he's done with his training, then we can just wrap up and we won't have more business to conduct.
Brandon.
Yep.
He also said that he's going to try to hop on at 1:45, so he might be here a little bit before 2, just so you're aware.
That's fine too. Yeah. So that works. So he might be on at 1:45. So with that being said, I don't know if any board members have any questions before we go into executive session, before I make the motion that we go into executive session. Okay. Hearing none, I move for us to move into executive session for personnel, employment, and discipline matters to be considered and allow, in addition to board members and our council, also allow Michael Hess, administrator of OPS, Jessica Watson, general manager of OPS, Jalecia Fair Johnson, the CPRB administrative assistant. I think that may be all we need. Is there anybody else I might be missing? Dahlia, Mike, Jessica? I don't think so. Okay, so hearing none, so that's my motion to move to executive session. So that's been seconded by Member Gatton. We'll need a roll call vote. Brandon Brown, aye. Diana Saganovich,
Aye.
Dave Gatton,
Aye.
Shanoa Miller,
Aye.
Edwin Moore,
Aye.
and Waverly Willis.
Aye.
All right, the ayes have it. So we will now move into executive session.
Hello, Mr. Sharp. Do you need to be put in the executive session? All right.
Okay, everyone, we are back from executive session, but we are going to take a short break before we kind of go back on the record with what else we need to do and before Dr. Whitmer Rich comes in for his training. So we're gonna let's have everyone come back at 1:40. Dr. Whitmer Rich is gonna be on about 1:45. So I want to try to cover as much as we can and not dig into his time too much. So let's try to be back at 1:40. Thanks, guys. All right, it is 1:41. So if we can start getting folks back on cam, we can get this thing moving. Once again, excuse my voice. All this weather changing has left me a bit compromised. But hopefully we can get through this next portion quickly. 1, 2, 3, 4, 5. Yeah, that's quorum. All right. So moving into new business. The first thing I want to address is the CPRB's response to the city of Cleveland and the U.S. Department of Justice's joint motion to end federal oversight in the city of Cleveland. One of the things that we really wanted to highlight and focus on at this time is that we are authorized and empowered by the voters of the city of Cleveland through Charter 115, not just through the consent decree. And so, we will continue to do the work that we were charged with under the charter, regardless of whether the federal oversight ends or does not end. Obviously, that decision now rests with Judge Solomon Oliver. But again, even if federal oversight does end, we are still empowered by Charter 115. We fully intend to continue to promote transparency and accountability. Obviously, policing in this city is far from perfect. And while we believe that our oversight structure is a strong one, it's very powerful. As a matter of fact, based on our experiences speaking with other oversight bodies throughout the country, in our attendance at the NACO conference and just through getting to know some of these other areas, we have one of the more powerful oversight structures, civilian oversight structures in the country. And while that is the case, a lot more work does still need to be done in order to continue to ensure effective, fair, and constitutional policing, and ensure that that remains in place for the foreseeable future. What we would hate to happen is for federal oversight to end, and then we see some sort of backslide or erosion of the progress that we've made. I'm confident that, and the board is confident that our work will still continue. And as long as the people are still put at the forefront of oversight, then we will continue to see growth and change. And that's what we saw with I think the consent decree sparked that, but the consent decree was not the end all be all of that. And we saw with the charter that we were actually, we being the board, was actually emboldened with more power and more duties and more responsibilities than what was even put in place by the Department of Justice or by the consent decree. And so with that, the doors of OPS are open. The work continues, and we will continue to do the work of the people. So that was, that's our stance on it as Civilian Police Review Board. And again, we welcome contact with the public. Hopefully you guys will see us out in the community. And everyone's always welcome to our meetings, second Tuesday of every month from 9 a.m. until 3 p.m., 9:15 if we're in person. And so, we want to continue to build a relationship between the public and our police department, because that's important for the safety of all. And so with that, I don't know if any other board members have anything else they'd like to particularly add. But yeah, the work continues, and that's what we're focused on, the work that has to continue. And that's what we've always been focused on. And that's what OPS has been focused on. They're the backbone of this thing, and they're going to continue to be so. All right. Moving on. as I stated, back to work. We there's a case that we've been that has been under investigation, 2025 dash 0046. And we did want to let the public know that there will be a presentation for that case. It will be scheduled for the March meeting. Again, this is case number 2025-0046. And that presentation will be scheduled for our March meeting. It'll be the second Tuesday in March. I don't have the date in front of me, but it's the second Tuesday in March. It'll be on that agenda. And we will have a presentation on that case, and we'll likely deliberate and make our decisions per usual. But we do understand that that case had a particular public interest. And so I wanted to.
That'll be March 10th, Chair.
Okay, March 10th. Thank you. So that'll be March 10th. Okay, so I'm gonna quickly jump to old business, and then I'm gonna jump back to our training, because I do see that we have Dr. Whitmer Rich here on the call. And I want to make sure that we wrap up everything, so that way all the time that's left is for him. So jumping in really quick in the old business, our administrative search, we are still moving forward on that. Right now, we have essentially narrowed the pool to just under 10 applicants. And we're looking to narrow it down to 5. And then from there, we're going to make some phone calls, and we're going to start setting up some interviews, and we're going to move on from there. Again, we've been pushing to try to get this done by our March meeting. Depending on how the interviews go, it may push past our March meeting. Most likely, it will call some sort of special meeting at some point in March. But just know that as soon as we have someone that we're confident in selecting, we're not going to wait for another meeting. We're going to call a meeting, and we're going to get that person hired, so we can be moving forward on that. Report on meeting with the monitoring team. I did have a meeting with Monitor Cole and deputy the deputy monitor as well, Deputy Monitor Stewart, and it was a great conversation. They were extremely helpful, and they wanted to talk about ways that they could help both the Civilian Police Review Board and the Office of Professional Standards. And so we went over some of the changes that we've gone through as an organization recently, some of the interim positions that we have in place, the fact that we're trying to put some standard operating procedures in place to try to make sure that our administrator, when they come in, is going to be able to hit the ground running and really get things done. And so it seems like they were pretty hardened by what they heard from us. We consider ourselves an organization that really prides itself on the work. And I'll keep harping on that. OPS has been doing the work. They're the ones who are clearing the investigations. None of this moves without them. None of these conversations happen without them. And when we're talking about civilian oversight, you can't have a civilian oversight conversation in the city of Cleveland, at least not one that paints a full picture, without the Office of Professional Standards, without the people who actually interview our officers, without the people who have their doors open for our citizens to walk through and make their voices heard. And you can't have that conversation without the Civilian Police Review Board. We're the ones who are carrying out all of the changes that are being made. So with that being said, the monitoring team meeting went very well. Obviously, with everything going on with the consent decree, we don't know what that relationship is going to look like going forward. But as long as the monitoring team is around, we consider them a strong ally and someone who's going to be in a group that's going to be very helpful for us. Okay, and finally, NACO preparation. Again, NACO is in November this year. We've had board members, you should have received in your email a form, inquiry form about presenting at NACO. I'd like for us to strongly think about that. I think that they're due in April, so we could talk more about this next month. But I really want board members to think strongly about whether or not, what we're going to present. I'll put it that way. Welcome to my reign of terror. I'm going to really push that we're going to present something. We've been to NACO these past 2 years, and what we've discovered there is that we have a very unique oversight structure here in Cleveland, and we are uniquely powerful in that there aren't I don't think there are any other oversight structures like this where the civilians are the ones who actually um, make determinations on discipline levels and discipline themselves. And so I think that that's something that would be very fruitful to talk about with the rest of the country and with the rest of the oversight bodies of the country, and talk about kind of the uniqueness of what we're going through. And then now we have another wrinkle of maybe we're going to be exiting a consent decree. And what does that look like? And exiting it not because the DOJ has given us green lights on everything, right? But because there's been a motion in place. So we have a lot to offer the country when it comes to our experience. And so I want you guys to really think about different topics that we may be able to cover. I know our senior investigator, Art Boker, he's planning on submitting a request if he hasn't already, um, speaking on some of the things that he's spoken with us about, which is about social media, living in a digital age, and what that means for policing and police oversight. So I'm looking forward to that. We got the opportunity to learn from Art last year, and it was a great discussion that we had. And so this is the opportunity for Cleveland to continue to put itself on the map in a positive way for change. And so, I'm really excited about this year's NACO. It's in Louisville, Kentucky, so it's essentially right down the block, um, compared to us going to Phoenix and Minneapolis. So it's relatively close. So I'm excited for this. So I don't know if anybody has any questions or anything about that right now. We'll talk about it again in March, but I wanted to put it on everybody's radar so we can start thinking about what we're gonna speak on. Okay, hearing none. Now we will have our main event of the show. I am happy to introduce Dr. Jonathan Whitman Rich. He is a professor over at Cleveland State University College of Law. I'm proud to say that he taught me everything that I know about criminal procedure. Um, and so I was thrilled that we were able to have you come in and talk to us a little bit about the Fourth Amendment. We've just to give you a little bit of background about us. We wrestle with these issues, somewhat often where we have an officer who may be involved in some sort of stop and search and seizure type situation, and we're often tasked with figuring out whether or not it was lawful, which can be, as you know, a complex and lofty question to answer. So I'm going to turn it over to you and let you handle it, and we'll go from there. Board members, I'm sure if we have any questions, we'll be able to fire those off at the end. So, all right, I'll turn it over to you.
Great. Thank you so much. Can you guys all hear me okay? Great. It's a pleasure to be here. Thank you for having me. I'm going to try to do kind of an overview of the Fourth Amendment, hit on some of the core issues. I'm happy to take questions as I go along. If we have time, I've got some short examples at the end that we could also talk about. But you guys see this all the time, so you know what this looks like. So I'm going to use a PowerPoint. I'm going to share my screen. Can you guys see the PowerPoint now?
Yes,
Yep.
we can.
Great. Okay, so the Fourth Amendment is the constitutional amendment in the U.S. Constitution that is most commonly used to govern police search and seizure. Of course, there are other sources of law for police behavior. There are federal statutes, there are Ohio statutes, the Ohio Constitution, and then, of course, police policies, right? Whatever their own policies are. And those are not always exactly the same as the Fourth Amendment, but I'm focusing on the Fourth Amendment today. So the Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So really briefly, just to note at the outset that this constitutional amendment has kind of two different pieces. There's the second clause, which we call the warrant clause, that basically says what do search and arrest warrants have to have in them. And then there's the first clause, which we call the reasonableness clause, that's more general. And courts in that clause focus on some of the particular things, which is You have a right to be secure against unreasonable searches and seizures. So again, you all, I think, are familiar with this, but whenever we're looking at a police-citizen interaction, the courts are always asking, well, when, if ever, was there a search? And when, if ever, was there a seizure? If there's no search and no seizure, the courts will say the Fourth Amendment has nothing to say about this. There might be other policy considerations, what the police should do, shouldn't do, but it's not going to violate the Fourth Amendment, right? So we focus on when is there a search and when is there a seizure? And if so, was that reasonable or unreasonable? And then that takes us into the whole body of law about when is a search reasonable and when is it not reasonable. So I'm going to try to touch on some of the big issues that come up most commonly in policing. So first of all, of course, there are these ideas of probable cause and reasonable suspicion. Probable cause shows up in the Fourth Amendment itself. Reasonable suspicion does not, but the court articulated it. Probable cause is the standard that's required for a search warrant or an arrest warrant. It also, if the police have probable cause that someone's committing a crime, they can arrest that person in public. They actually don't need an arrest warrant. They can just do that if the person's in public. And they can also search automobiles if they have probable cause that there's evidence of a crime inside an automobile. They don't need to get a search warrant for automobiles. Reasonable suspicion is a lower standard. There's no clear line like what's one versus the other, but it's a little bit of a lower standard and allows police to do something that's less invasive, but it's still a seizure or a search. And that is the police can conduct a brief detention of the person to try to figure out what's going on. And they do that if they have reasonable suspicion the person's involved in criminal activity. And they can also pat them down or frisk them for weapons. It's not a full search, but a frisk. And for that, they need reasonable suspicion that the person is armed and presently dangerous. So the brief stop and the brief frisk are often put together. That's reasonable suspicion, but they actually are two different standards. The one requires reasonable suspicion of some criminal activity, but the frisk requires an additional level of suspicion, which is that the person is armed and dangerous. Okay, so a little bit more on that, right? Probable cause, we could say, are specific facts and circumstances that would cause a reasonable person to believe that a crime has been committed and that the person, place, or thing is involved in the crime. And reasonable suspicion is a lower standard. It's still more than just like a hunch that you can't articulate, right? It's got to still be articulable and specific. But those are kind of the two key standards that we're dealing with. Excuse me. So very briefly on warrants, right? A warrant could be a search warrant or an arrest warrant, a document that's issued by a judicial officer, a judge, or a magistrate that essentially authorizes the police to conduct a search or to make an arrest or a seizure. And typically, search warrants are required to enter and search a home or the private parts of a business, right? If the police go into a public place of business, that's the same as you and me, we can do that. But a private part of a business, they need a search warrant. So to enter those places. They also, in general, need search warrants to open containers. Containers means any number of things like a suitcase, a backpack, even a garbage bag, if it's tied off, is a closed container. Another thing, of course, that's a container are these things, right? A cell phone is a form of a container. There's a lot of information in this container. And the police can search it with a search warrant, right? But they have to show probable cause, get the judge to issue it. There are instances where the police can search your bags without a warrant. I'll talk about those in a minute. But I think that's one thing that, because the police can arrest people without a warrant, they often think, well, they can probably search all of their stuff without a warrant if they have probable cause. We'll talk about, there are some rules for that, but in general, to get into a container, the police need a warrant unless there's an exception that applies to that. Okay, so what does a search warrant require? This comes right out of the language of the Fourth Amendment, right? No warrant shall issue but upon probable cause, meaning the officer has to provide the facts and circumstances that give rise to probable cause that there is evidence of a crime. They have to make that assertion under oath or affirmation. And then the warrant has to have particularity, and it has to have two types of particularity: the place to be searched and the person or things to be seized, right? Those have to appear in the warrant itself. And those are designed to sort of allow the judge or the magistrate to direct the officer about what's going to happen, rather than just leaving it all to the discretion of the officer. Warrants are generally required to conduct a search unless you have an exception. And I have the exceptions listed here, and there's kind of an acronym that we sometimes use, SPACES. And I'm going to try to touch on at least some of these. And these are ways to think of the exceptions to the warrant requirements: search incident to arrest, the plain view rules, rules about automobiles, consent, exigent circumstances, and the special needs doctrine. Okay, so I'm going to go through those one at a time. So this is an extremely commonly applied exception to the warrant requirement. I just finished saying that ordinarily to get into your backpack, your purse, whether it's locked or unlocked, the police need a warrant. It's a container and they need a warrant to get in there. One very commonly invoked exception is search incident to arrest. So when the police conduct a lawful arrest of a person, they have probable cause. The police can search all of the items that the person has with them. That includes like going through their pockets, opening up their wallet, a full search, not just a pat down for weapons, but this is if they are lawfully allowed to arrest someone. And so if you have a backpack on you, they can go through the backpack, they can open up all the containers inside. Right. One very important exception to that gets us back to this document, right? Or this item, the cell phone. The court said cell phones are kind of unlike the other things that you're carrying around because they contain so much private information. So in general, the court said we're going to require warrants for cell phones or other similar digital devices. Probably if you're carrying a laptop, the courts are probably going to treat that like a cell phone, that you have to get a warrant to open the laptop. You can't just search it automatically incident to arrest. But so this is a very common scenario. Police arrest somebody. They are then allowed to search all of the items the person has on them, with the exception of the cell phone. They can seize the cell phone if they have probable cause. They can go get a search warrant for it, but they can't search it without some other lawful reason. In addition, if the police arrest somebody inside a building, like inside their home or in a business, they can conduct a protective sweep of some areas around where the person was arrested, checking that there are not other people present who might pose a danger to the police. So that's another kind of search incident to arrest authority. Okay, so you don't need a warrant to open the bag if you're conducting a search incident to arrest, right? You've lawfully arrested the person. That's one exception. Another set of rules are the plain view rules. And the plain view rules simply recognize that the police, using their senses, other than the ones that require physical touch, right? Because physical touch is a search. But the other ones, right? Smell and hearing and sight, those are not searches under the Fourth Amendment. So if the police are, standing in a driveway and they hear someone screaming inside, hearing the screaming is not a search. That's just, it's in plain view, it's in plain hearing. The police are allowed to collect that information. They don't need some justification for doing so. The critical thing about the plain view rule is that it allows the police to use their senses when they are lawfully present, but the rule itself does not allow the police to enter into any constitutionally protected area. So, if the police can see through, they're standing on a public sidewalk and they can see through a window that there's a pile of drugs and drug paraphernalia in the front room of a house, right? They've seen that lawfully. It's in plain view. They're lawfully present, but that does not allow them to enter the house. The police now have probable cause that there are illegal drugs inside this house. They could get a warrant. We'll talk about other reasons they might be able to get in, like consent. But just seeing the drugs themselves does not allow them to enter the house. One very important part of this rule that I think is very easy for police to kind of make mistakes about is the issue of curtilage, which your home is protected by the Fourth Amendment. And then there's an idea of curtilage, which is an area around the home. It's hard to define precisely, but there's a little buffer zone, right? Because if the police are not allowed to enter your home without a warrant, the court has reasoned, they also can't just walk like straight up to the edge of it. And, as long as they don't touch it, they can look through all your windows. No, the court said there's a little buffer zone of property around your home that is the curtilage of the home, and that is protected by the Fourth Amendment, just like the home is. This is an area where police can sometimes get into trouble because they kind of know, okay, I can't go inside the house, but can I walk right up next to it? And the answer generally is no, unless they have a warrant or consent or exigent circumstances. And in particular, if the police see some illegal item within the curtilage of the home, something right up next to the home, they have an impulse, of course, like, okay, I've seen this, it's in plain view, now I have probable cause, I'm allowed to go seize that item. In general, that is not true unless they have one of these exceptions. So the Supreme Court had a case a couple years ago where the police saw a bicycle that they believed to be a stolen bicycle, and they were correct. It was a stolen bicycle, parked right up next to the side of a house, up on the driveway, right next to the entrance to the home. And they walked up to check if it was the stolen bicycle. And they said, well, we don't need a warrant to search automobiles, which is correct. So we're okay here. And the court said, the problem is not the automobile. The problem is you entered the curtilage of the home. And even though you saw what you thought was a stolen bicycle there, you need consent or a warrant or exigent circumstances, and none of those were present. So to even approach and get really close to the house, the police have to have a lawful basis to do that. And just seeing something illegal there is not necessarily enough. Okay, so that's the plain view rule, right? So search incident to arrest, plain view. Next, automobiles, okay? So automobiles, the court has crafted kind of a unique set of rules governing automobiles that are kind of different from homes and different from even suitcases or backpacks. In some ways, an automobile has less protection than even a backpack that you're carrying around with you. And most notably, as I said earlier, what we refer to as the automobile exception, which is that unlike a backpack, unlike your house, if the police have probable cause, they can simply search the automobile based on that probable cause. They don't need to use that probable cause to go get a warrant. And this is true whether somebody is there and looks like they might drive the car away or not. The car could be abandoned and sitting somewhere where they know it's not going to go anywhere. They have no reason to think anybody's going to access the car. It's a blanket exception, the automobile exception. They still must have probable cause that the car contains contraband or evidence of a crime. But with that probable cause, they can conduct a complete search of the car, everything in the car, all of the containers inside the car, the trunk of the car, even if the trunk is locked, if they have a way to get it open. So that's a very broad search authority. It does require the police to have probable cause that the car contains contraband or evidence of a crime. But they don't have to check with a magistrate whether they really do have probable cause ahead of time. They do the search, and then if somebody later moves to suppress it, somebody else is going to decide, some judge will decide whether they really did have probable cause, or a body like you all will decide, did they really have probable cause after the fact, right? So that's the automobile exception. There are some other exceptions as well for automobiles that relate to our other rules, like search incident to arrest. Again, I mentioned search incident to arrest. The police can search the person and the stuff they have with them. For automobiles, the way that rule works is that if somebody is arrested in or near an automobile, and by this I don't mean they're on the street and there happens to be a car next door. I mean a car that they are connected with, right? Maybe it's their car, or they just got out of it, or they're about to get into it. But the person is under arrest and they're in or near an automobile. If the person can reasonably access the vehicle at the time of the arrest, then the police are allowed to search the entire passenger compartment of the vehicle. So now this is a little bit more limited than the probable cause rule, which was the entire vehicle. Passenger compartment means not the trunk, basically, right? Anything in the passenger compartment, including containers. So again, you can open bags and look in the bags in the passenger compartment. But this rule, importantly, is limited to, you can do that kind of a search during any period when the person under arrest can access the automobile. It's not uncommon that when police arrest somebody near an automobile, they place them under arrest, they put them in handcuffs, and they secure them, which makes sense. Maybe they put them in the patrol car, maybe they move them far away from the vehicle. If the person under arrest is no longer able to access the car, then this search incident to arrest authority does not exist anymore, right? So it follows the person around in essence, right? The arrestee, when they can access the car, that gives the police authority to search there. But once they leave, once they're out of there, then that search authority no longer exists. Police are also allowed to conduct inventory searches of vehicles when they impound them lawfully, right? So the police will find a car, or they arrest the driver, say he's driving under suspension, they put the driver under arrest, they have to impound the vehicle. They can't leave it just on a public road somewhere, right? So any reason that they're lawfully impounding the vehicle, they're permitted to perform an inventory search. And here the Fourth Amendment rule is that the inventory search has to be reasonable and they just have to follow their policy. So the Cleveland Division of Police has an inventory search policy. I've read it, not recently, but I think it allows them to search the car, including the trunk, and containers inside the car. And the courts have said that's a reasonable policy if that's what you want to have. And so if they're impounding a vehicle, the police can do those kinds of searches just as an inventory to see what is in there, make sure there's nothing dangerous in there, make sure there aren't any weapons that could be dangerous on the impound lot, that kind of thing. So that's another basis for a lawful search. And of course, often searches automobiles are searched lawfully due to consent, which is our next issue, right? So consent is something that you probably encounter a lot, right? Disputes over consent. Did this person consent? Because a lot of times when the police are, interacting with the public, they will ask for and sometimes receive consent. And consent is an exception to the warrant requirement, right? If the police ask somebody to stop and the person says, yeah, that's fine, I'll stop, then they haven't been seized. It's just a consensual encounter, according to the courts, right? The courts are not very sensitive to the idea that a lot of ordinary citizens, of course, feel like, well, if the police ask me to do something or if they ask me to stop, I just need to do it, right? They're the police and I just need to do it. The courts have taken the view that you can decide if you want to do it or not do it. And if you do it, you've consented to it. So they don't need probable cause or reasonable suspicion for that seizure because it's not a seizure. It's just you consenting to stop and talk with the police. Likewise, if the police ask, do you mind if I look through your bag? And you say, okay, I guess, right? That's going to be viewed usually as lawful consent. And it doesn't matter, these other exceptions I've been talking about, they aren't needed anymore because the person consented. Similar with automobiles, right? Can I look through your car real quick and make sure you don't have any weapons in here? If the person says, okay, yes, something like that, it becomes a consent search. So this is a very big, this is a very commonly, issue that we encounter very commonly, that people say yes to the police, and the courts take the view that that's perfectly okay. One thing to keep in mind is the scope of the consent, like what counts in the consent. And with an automobile in particular, the test is sort of like, well, what would a reasonable person assume based on the encounter with the police, right? If the police say, sometimes the police will just say something like, can I look in the passenger compartment? If the person says yes, then the police officer just limited the search. They said, can I search the passenger compartment? That's all that was consented to because that was the interaction. So then they're not allowed to look in the trunk. If the police just say, can I search the car in general? And the person says yes, the courts are going to say, well, that reasonably includes the passenger compartment, containers in the passenger compartment, and the trunk. But it's not going to include things that are locked unless you follow up and say, can you unlock this for me, right? So if the police have to pry open the trunk because it's locked, the courts will say, well, when the person said, yes, you can search the car, that did not include prying open the trunk. That's unusual and exceptional. You would have to ask, hey, can you unlock this trunk for me? Interestingly, the Cleveland Division of Police, their policy with regard to consent, the last time I looked at it, is actually more protective than the Fourth Amendment. And so, for example, a couple things that, under the Fourth Amendment, while the police can get consent, they're not required to give people a warning of can I search through your car? By the way, I just need to inform you that you have a right to say yes or no. It's up to you, right? They're not required to give that kind of a warning by the Fourth Amendment. We think of those warnings like in an interrogation context under Miranda, right? Give the Miranda warnings. But for a consent search, those rules are not required by the Fourth Amendment. Again, I'm not 100% sure this is up to date, but the last time I saw it, the Cleveland Division of Police policy says, where an officer seeks consent for a search, the officer shall inform the person in an age-appropriate manner of his or her right to refuse and revoke consent at any time. So that's a case where the police policy requires them to inform people they have a right not to consent if they don't want to. So it's going beyond the Fourth Amendment, which is perfectly sensible. The US Supreme Court has always made it clear we're setting kind of the minimum floor when we're setting the rules under the Fourth Amendment. But a local police department, a local city, a state may decide that some additional protection is required, and that, in the court's view, is perfectly appropriate. And the division also requires that that the police record the consent on their wearable camera system, so that there should be, in most cases, right, a clear record. What did the officer ask, and what did the person say? There should be a clear record of that consent. And so, you know, if the police say, well, they consented, but they don't have that documented on their wearable camera system, that probably is a violation of policy, because it needed to be, the policy requires it to be recorded on the camera system. And again, it requires them to say, you know, you have a right to refuse or revoke this consent at any time if you want to. So that would be a violation of policy not to give that kind of warning or information as well. Okay, another common scenario is exigent circumstances. We can think of this as kind of an emergency situation in general. And so, not surprisingly, in certain types of emergency situations, the police are allowed to conduct searches or seizures without, say, going and getting a warrant all the time. And in particular, the three scenarios that the court has identified are: the police are allowed to conduct a search, including entering a home without a warrant, in three particular circumstances. One, when they're in hot pursuit of a fleeing felon, right? The police are chasing someone who they have probable cause to believe committed a felony. They're pursuing them from somewhere in the city, in the neighborhood, and the person runs into a home. It might be their home, it might be some other home. The police are allowed to chase them right in, right? They don't have to pause at the door, figure out whose home it is, ask for consent, try to get a warrant. They are allowed to continue their pursuit of a fleeing felon, right? So that's one thing. The US Supreme Court has clarified recently that this only works for fleeing felons, because that's a more serious type of offense. If the person is suspected of committing a misdemeanor and they run into a house, police can knock on the door, they can ask for consent, they can see what they can do. But just suspecting someone of a misdemeanor does not allow you to enter the house in hot pursuit of that person. It has to be a felony. Other very common, commonly invoked form of exigent circumstance: when the police reasonably believe they're facing the imminent destruction of evidence, right? If we don't enter right now, we're going to lose evidence, and we have reason to believe that. This, of course, most commonly happens in drug investigations, because part of the imminent destruction of evidence is, well, how easily can you destroy the evidence? And drugs in small quantities can be destroyed pretty easily, right? You can put them down the sink, you can burn them in your fireplace, whatever, right? And so when the police have probable cause to believe that there are drugs inside a residence, and in particular, once the people inside know that the police are outside, now it becomes very likely that they're going to try to destroy the evidence. So any kind of what the courts will call furtive movement, right? Any kind of noise, it sounds like the people inside are doing something to try to, you know, evade the police. The police are allowed to just enter now to try to preserve the evidence, prevent that from being destroyed. Very commonly invoked in drug investigations. And finally, third, the police reasonably believe that their immediate entry is necessary to prevent an imminent harm to the police or to other persons. So this doesn't even have to be a criminal situation. It can be, of course, but it doesn't have to be. You could have someone who, you know, the police reasonably believe that they're passed out in their family room and they just need emergency assistance, right? Doesn't really matter if a crime occurred or not. They're allowed to immediately enter to try to render emergency assistance. It also covers criminal situations where two people are fighting inside a home. It looks violent. The police can simply enter. They don't need to knock. They don't need to go get a warrant, and so forth. So that's exigent circumstances. And finally, special needs searches. And this is a category that applies when the police are not conducting a criminal investigation or criminal law enforcement. It's kind of, they're doing something else, which police do a lot of other things as well, right? Some kind of administrative thing. And a search can be reasonable and lawful even without a warrant when the police are conducting an appropriate special needs search. This can include, although the boundaries of this, frankly, are kind of unclear, something that we often refer to as a welfare check, right? The police get a very common scenario. They get a report. My neighbor is really elderly. I usually see her every day or two. I haven't seen her for a couple days. I've tried knocking. She's not answering her phone. Somebody needs to go check and see if she's, in an emergency situation or needs assistance. And in general, the courts have said, that doesn't require you to have probable cause that a crime committed. It doesn't require you to go get a warrant. The police can, they should knock, but they can enter the home based on, the need to perform a welfare check, as long as the police are kind of acting reasonably. They're not being excessive in what they're doing. Okay, so before maybe turning to some examples, let me close by trying to talk about new technologies. This is a huge issue in the Fourth Amendment and with policing in general, right? Because we have this proliferation of new technologies, new things, new ways that the police can gather information. And so what are the Fourth Amendment rules on new technologies? The problem here is it's kind of a thorny mess. And the reason is that in general, the police are allowed to be in public and make observations, right? The police can stand on a street corner and just watch and see who goes by. They can even follow a suspect around a city, right? They're allowed to do that. Things are in plain view, sort of like you assume the risk, you're out in public, maybe the police will see what you're doing. But when the police use advanced technologies to kind of do those same things, sometimes the result is a much more serious invasion of privacy. So it's one thing to say, occasionally there's a police officer standing on a corner, but what if there's a camera that records every single thing that happens 24/7? Well, that's much more invasive, of course. It's also more effective from a law enforcement perspective, right? So there's a balance here. Following somebody around in public for a brief period of time is okay. Well, what if you can just track their location for, over a 3-month period? You just track everywhere they go in public, right? So these are thorny problems. And in a very important case in 2018 called United States versus Carpenter, the court started to put some limits on how the police can use some of these advanced technology. And in that case in particular, they were thinking about location tracking. And they held that kind of detailed long-term surveillance of a person's movements, even if it's just movements in public, if it's long-term surveillance, that can be a search under the Fourth Amendment that requires a warrant. And the police are not just allowed to do it whenever they want. They could do it if they got a warrant, but they would need a warrant. And why? Because even though you're looking at someone in public, if you can track their location for months, you're going to really learn a lot of very private and intimate details around that, about that person. It can provide an intimate window into the person's life, revealing their familial, political, professional, religious, and sexual associations, the privacies of life, the Supreme Court said, right? So there are some limits the more comprehensive and detailed this kind of surveillance becomes. Unfortunately, there is not really a bright line to be able to tell the police or all of us, like, how much surveillance is too much surveillance. The court in Carpenter said things like, well, location information from cell phones, for example, everybody carries around their cell phone and it provides very detailed location information. So if they want to they don't even have to get it from me. They could get it from my cell phone provider, right? Like, please provide us with Whitmer Rich's location over the past year using his GPS that's in his phone, right? I think Google could they have those records. They could just provide them. My internet service, my cell phone provider could just provide them to the government. And suddenly the government can look back and see, oh, this is where he's been for the past year. super helpful in an investigation, right? But to be able to get that level of detail, the court said you're going to need to get a warrant to do that because it's just too, it's a large amount of information. It's very detailed over a long period of time. It allows the police to essentially look backwards, even when they didn't know that they had suspicion about me. They can go backwards by using this phone, where my location was a year ago. And this is generated just very cheaply and easily. So exactly what the boundaries of that are really still very unclear. But that's a very important issue. It can be a dilemma for police departments because essentially, the more effective their technology is, right? The more information it gathers, the more detailed against more people, the more likely it is that maybe they're not allowed to be doing that under the Carpenter case, that they need a warrant if they're going to do it. So that's a little bit of a dilemma for law enforcement. Okay, so I'm happy to take any questions. I'm also happy to give just a few scenarios, examples to kind of illustrate how some of these principles work. But before I do that, any questions from what I've covered so far?
Well, first of all, thank you so much for that. I really appreciate it. I know we're not quite done yet, but I just want to say I appreciate the presentation. It's always good to get a refresher and kind of understand some of these nuances that, we often, wrestle with. Um, One thing that did stand out to me was just reasonable expectation of privacy and
Yes.
like reasonableness. And so if we're talking about, like trash on the front lawn or um certain things like that, then officers may not need a warrant for that, and it don't really need an exception because there's no reasonable expectation of privacy. For instance, with trash on your
Right.
front lawn because it's basically deemed to have been discarded,
Yep.
right? So I don't know if maybe you could talk a little bit about that and maybe if there's any other examples when maybe there's not a reasonable expectation of privacy and essentially so then the warrant requirement isn't there.
Yeah, right. So yeah, this is the what we would call the abandoned property doctrine, and trash kind of fits under that, depending on where the trash is, right? And the court has kind of said, well, even if you had a Fourth Amendment interest, or as Brandon said, a reasonable expectation of privacy, that's another way to talk about like I have a Fourth Amendment interest in this. If we remember from the very beginning, the Fourth Amendment protects you against protects your person, house, papers, and effects. Person, house, papers, and effects. So to be able to say my Fourth Amendment rights were violated, I have to be able to show that they touched on one of those things, right? So if they go to my neighbor and my neighbor gives a bunch of photographs of me doing something illegal, well, that's not my person. It's not my house. It's not my papers. It's not my effects. My effects are my personal property, like my phone is one of my effects, right? So if the police can gather information that can be very incriminating and even reveal a lot of private information about somebody, but if it's not essentially my stuff, if it's not an area in which I have a Fourth Amendment interest, then it's not necessarily protected. So Ms. Lampkin, I'll comment on that in a minute. Juveniles, excellent question. So this roundabout way to get back to Brandon's question, which is if you have abandoned something, even though you used to have a reasonable expectation of privacy in it, you've kind of given that up. And the court has said when you put your trash out on the curb for the garbage people to come and pick up, even though you're not really expecting other people to pick it up, the police can do that if they want to. They can pick it up. They can go through your trash because you don't have a Fourth Amendment interest in that anymore. You've given it up. Now, one very important clarification there is where is the trash located? Because like I said earlier, the police are not allowed to enter your home or the curtilage of your home. So, last I knew, I don't live there, but people have told me that like in Shaker, you don't put your trash out on the curb. You leave it up by your house and they come up and get it there. Okay. And so if your trash is up right next to your house, the police cannot come up and get that trash, even though it's, out for collection or whatever, because they would have to enter the curtilage of your home to do so. And that curtilage is protected. On the other hand, if you put it out on the street corner, the police can grab it, they can take it back to the station and they can go through it because you no longer have a kind of Fourth Amendment interest in that item. Okay, so let me turn to Ms. Lampkin's question about how the Fourth Amendment works with juveniles. That's a great question. I don't perfectly remember all the rules, but I do know that the Cleveland Division of Police policies actually do specifically discuss juveniles at various times. And some of those policies, again, go beyond what the Fourth Amendment requires. And I think that's good that they specifically try to think about juveniles. This is, of course, is very common. I mean, I guess I would say in general, there's kind of a mix under the Fourth Amendment where the court at times have said, yes, you have to take into account if somebody is a juvenile. For example, a very young person, you knock at the door and a really young person answered, you say, can I come search around the house? They say, oh yeah, okay. Well, an 8-year-old does not have the authority to consent to the search of a home, right? However, the court has been pretty, it doesn't require, for example, that you be a full adult, like an 18-year-old. So if the police knock on a door and a 15-year-old comes to the door and they say, can we search this house? And they say, well, my parents aren't home. And they say, I know, will you let us in? And they say, okay, fine. The Fourth Amendment, the courts will probably say that's a valid search. A 15-year-old can give valid consent. I do think, like I said, that the Cleveland Division of Police policies are a little more protective of juveniles. They give them, they require the police to be a little more sensitive toward the interests of juveniles. I think it's a very important thing to think about. But the Fourth Amendment is not overly sensitive to that issue, I guess I would say.
Thank you.
Any other questions?
I have one more thing, and that's about pretextual stops. So a lot of times we deal with claimants who may say, oh, this officer followed me around and they were just looking for something to
Right.
pull me over for. And eventually, I don't know, I rode through a stop sign and they stopped me, but that's not really why they stopped me. They really stopped me because they wanted to be able to see if I had drugs in the car or whatever. But
Yep.
we've often run into this idea of, oh, the police officers had nefarious intentions and
Right.
they're just hiding behind this technicality that I may have committed a traffic infraction or something like that. Can you talk a little bit about the legality of that?
Yeah, that's a great question. So, under the Fourth Amendment, the court has held that the Fourth Amendment does not prohibit pretextual stops. So, the case here is called Wren, WHREN. And the court said if the police observe, say, a traffic violation, we're not going to look into whether they were quote unquote really motivated by something else, right? And so this is a huge issue because people feel this way a lot, and I'm sure some of the time it's true, right? That the police are really wanting to stop this car because they're interested in seeing if there are drugs in the car, but they don't have reasonable suspicion or probable cause. They haven't developed that yet. So they follow it until they see a traffic violation, and now they're allowed to pull the car over for the traffic violation. Now, keep in mind, that doesn't allow them necessarily to search the car, right, or to arrest the person in the car, but it does allow them to pull the car over. So a pretextual stop, even if it seems very obviously pretextual, and I've seen cases, I mean, police officers know that they're permitted to do pretextual stops or they're not prohibited by the Fourth Amendment. So I've seen cases where police will just talk about it ahead of time, right? They're like, I think this guy has drugs in his car, so as soon as I see him commit a traffic violation, I'm going to pull him over. I mean, that's it's not necessarily it's not a Fourth Amendment violation. So, and to my knowledge, it's not a violation of division policy either, that the Cleveland Division of Police does not have a policy that prohibits pretextual stops. It's an important area and it's difficult because on the one hand, it does seem like a problem and a violation of rights. I mean, I agree with that because in general, the police shouldn't be able to pull you over to investigate if you have drugs unless they have reasonable suspicion that you're involved in drug activity. And this seems to give them like a loophole because if you follow anybody around driving for more than a minute or two, you're going to see some traffic violation. So that seems like a big problem. On the other hand, if it were a Fourth Amendment violation, and the reason the courts, I think, didn't go there is because it might, in many cases, be very hard to sort out. Well, I don't know. I mean, I think they maybe were interested in the drugs, but they also did see the guy run the red light. Like, are they just supposed to ignore the red light getting run? Like, it's just hard to tease those out, right? And so for that reason, the court said, we're not going to prohibit pretextual stops. But it is a big issue that people in public, get upset about and feel like they're not being, treated the right way. But currently the Fourth Amendment does not prohibit that practice. I think there was a question about smelling marijuana in automobiles, right? That's a really great question and a really important issue. So, until just a couple of years ago, of course, if the police smelled any odor of marijuana, courts basically said that gives you probable cause to believe that there's marijuana in the vehicle. Marijuana is contraband, and therefore you're permitted to search the entire vehicle, right? Just like automatic search authority. You smell marijuana emanating from the vehicle. I would say now the answer is much more complicated, and the case law is still trying to the courts are still trying to figure out exactly how this is going to work. In the case of a vehicle that's been driving, there is a big difference, for example, between smelling the odor of raw marijuana and smelling the odor of burnt marijuana. And police, everybody will tell you there's a big difference between the odor of raw marijuana and burnt marijuana. If the police pull over a vehicle, the window comes down, the smoke billows out of the side, and they smell burnt marijuana, that gives them, it's not the possession or use of the marijuana that is illegal. It's the use of it while driving, right? You can't be smoking marijuana while you're driving. And so now you have a driving under intoxication potentially, and you have reasonable suspicion, maybe probable cause of that. That could allow you to potentially arrest the driver, and it could potentially allow you to search the vehicle for evidence of that driving, while intoxicated violation. In contrast, do a traffic stop, roll down the window, the driver seems alert and oriented, they don't seem intoxicated in any way, and you do smell raw marijuana in the vehicle, there's no, I'm not sure why that would give you probable cause of any criminal violation of any kind. So, I do think, again, this is an area that is really under transition, but it's important, I think, for you all to think about this as, what is the crime, and is there reasonable suspicion or probable cause of that crime? And again, with automobiles, the crime can be, driving under an intoxication, and that's a serious issue. But the mere smell of, in particular, raw marijuana doesn't necessarily give rise to any suspicion that the person is, in that situation, because raw marijuana, it's unlike, alcohol is different. It's open container laws. As long as you have the closed, you're not going to smell the alcohol. But marijuana, even if it's not being used, even if it's in a bag, it's going to give off a very strong odor. So you can get that odor even when, there's no use and no particular suspicion of use. There's a question there about the number of exceptions. When I was a teen, I learned there were 10 exceptions to the search warrant rule, now down to 6. I think it depends how you count. I can't think of any that have been eliminated recently. So it's sort of like, it depends how you categorize them. But, like just with automobiles, I talked about that as one rule, but really there are about 6 or 7 different automobile rules just for automobiles. So, it get pretty detailed and specific. But I do think that basic framework of spaces does kind of cover the broad categories in which there are exceptions, and at least gives you some guidance in how to think about it. Any other questions right now? These are great. I'm happy to talk about some of these examples. If you want to take a little time to do that, Brandon, unless we're out of time, it's up to you.
No, that works. We still got a little bit of time. Yeah.
Okay, great. So here, I think I'm still sharing my screen, right? You guys still see this?
Yep.
So here's a consent example. You're walking down the street with a friend after leaving a store. A police officer says, "Excuse me, can I talk to you for a minute?" You both stop walking. You don't say anything. The officer says, "Would it be okay if I quickly look through your bags?" You don't say anything. Your friend maybe pauses and says, "Sure, we have nothing to hide." The officer searches your bag and your friend's bag. So any Fourth Amendment violations there. So first of all, did the officer seize? So great, Angela's telling me maybe there's a rights violation. Did the officer seize you and your friend? And what do y'all think? Did the officer seize you and your friend?
No, I don't think there was a seizure there because I mean the officer just asked, "Can I talk to you?" In the
That's
same
right.
way anybody can ask, "Can I talk to you?"
Perfect, right? And here, I actually think courts are usually relatively sensitive, and you all should be, I think, pretty sensitive about like sometimes you have footage of exactly what happened, right? So you can say not just a description of what happened, but hear what the officer said. And I do think that the Fourth Amendment draws usually a pretty bright line between like a command or an order and a request. And it can even be a polite command, but a polite command is a command. And if you comply with it, you've been seized. If the officer says, "Ma'am, please, I want you to stop. I need to ask you a few questions." That's a command, right? It was polite. They said, "Please," but they were telling you what to do. And when you stopped, you have been seized. On the other hand, if the officers ask a question, usually complying with a question or agreeing to a question will be viewed as consent. Right? So you want to be sensitive about that when you're looking at scenarios. And so in this case, "Excuse me, can I talk to you for a minute?" and you stop, the courts will say that's a consensual encounter, no violation of the Fourth Amendment so far. So then one of you says we've got a rights violation. Angela, where do you think the rights violation here is?
I would say since it's your personal property, your bags that you're carrying and you didn't consent, that's where the violation would be.
Perfect. I think that's right, right? Your friend said, sure, we have nothing to hide. So your friend has consented to a search, right? But your friend can't consent to the search of your bag. They can consent to a search of their bag. So here we have a case, I think, where the police are allowed to search your friend's bag because they responded and they said, yeah, sure, you can search. But you didn't respond. Some prosecutors will sometimes, or people will sometimes argue, my students sometimes think, I'll put it that way. My students sometimes think, well, they asked and you didn't say anything, so therefore you consented. That's not really how it typically works. The police need somebody to consent to count as consent. The fact that you did not say anything does not mean I therefore consented, right? The police need to get something from you that indicates, okay, or, yes, you can search my bag. It might be grumpy consent, but it's consent. But if you don't say anything, you have not consented and they are not allowed to search your bag. So no violation through asking them to stop, no violation by searching the friend's bag, but they did violate your rights by searching your bag because you did not consent. And in this scenario, there was no other reason for them to be suspicious about anything. Very good. How about this one? You and your friend are leaving a store. While you're leaving a store, the alarm goes off, right? And you start running. Police officer responds to the alarm, sees you guys running, chases after you, orders you to stop. You stop. You say, we weren't doing anything. They pat you down to search for weapons. So are they allowed to order you to stop? Are they allowed to pat you down for weapons in this scenario? What do you think? Angela says yes. Anybody else? What do you all think? Can they do this here? Brandon's giving me a thumbs down. Key thing about this scenario is thinking about the two different components of what happened.
I was going to say, I think the first part.
And the stop. So, Brandon, do you think it was okay for them to order them to stop?
Yeah, I think it's okay to order them to stop.
Good, right? I think not probable cause to arrest somebody, but leaving a store, the alarm goes off and you start running. That's reasonable suspicion that you get to stop that person. You can't just immediately put them under arrest. You don't even know if something's been stolen. Often the alarm just goes off for no reason, whatever, right? But you can at least stop them to investigate. Do you have reason to believe in this scenario that these people are armed and dangerous? You think so? Because they were walking out of a store? Give it your best shot. Let me hear it.
Terry versus Ohio was just based on casing and being
Correct.
on the sidewalk.
They were based on casing a store that made the officer believe that they were going to burglarize the store. So burglarizing a store, the court said that often involves weapons. You're going to burglarize a store, right? You're really casing it ahead of time. Shoplifting, does shoplifting, like I carried a expensive bottle of shampoo out of a store, does that usually mean like the person probably has a weapon on them?
No, it doesn't mean that.
Does it mean, you know, is there reasonable suspicion that they have a weapon on them?
I think when you're coming in contact with somebody that just committed a crime, that would be a reasonable suspicion.
I think, you know, people are going to disagree about this. And so I'm not going to tell you like there's a for sure right answer but I do think that it's worth remembering that there are some cases where you have reasonable suspicion of criminal activity, but really no suspicion that the person is armed and dangerous. Because sometimes criminal activity goes with weapons very kind of strongly. And other times there's really not much of a connection there, right? It would be surprising or not necessary. So my view would be in this case, maybe you have reasonable suspicion that they were just shoplifting from a store. People don't usually bring a gun along to just shoplift something from a store. But, you know, you can disagree. I mean, sometimes they might. Maybe it would depend on other factors as well. You look at the whole scenario. The court will look at things like what kind of a neighborhood is it? How high crime of a neighborhood is it? How likely are people to possess weapons in this neighborhood or not? So there can be other factors there as well. Good. Okay. Other discussion of that? I think that's a good discussion. Let me see. Okay. How about this one? You're driving your friend home from the store. You're driving about 40 miles an hour in a 35-mile-an-hour zone, which of course is a speed that the police usually tolerate. You can usually drive right past a cop going 40 in a 35. They're not going to pull you over usually. This time they pull you over. Police says, get out of the car, and they start searching the car. They say, we're searching your car because it matches the description of a car that was recently used in a robbery. The description from the robbery was, it was a late model black Ford Focus, and you are driving a Ford Focus that is black and that is 10 years old. So first of all, was the stop legal? What do y'all think? Was it legal for the police to pull over this car? It was. You were going 40 in a 35. Doesn't matter that they never pull you over for that. It's clearly pretextual, right? They're doing it because they think you might be involved in this robbery. But they're allowed to pull you over because you were violating the speed limit. Are they allowed to search your automobile here? What do y'all think? Samantha says no on the chat. We got a thumbs down, a couple thumbs down. Good. So what would the reasons be? Maybe some right. Did they ask for consent? Well, there's no evidence here that you consented, right? If the facts said, they said, we think this might be involved in a robbery. Can we search your car? And you said yes, then it's a lawful consent search. But the facts don't say that here. So it appears that they just pulled you over, got you out of the car, and started searching. No consent. Why else can they search a car? Well, they can search if they have probable cause that the car contains evidence of a crime. And this car matches the description of a car that was recently used in a robbery. So why are some people giving me a thumbs down about this? What do you think?
I don't know that the level of description is specific enough to get us all the way to probable cause. I mean, maybe reasonable suspicion, you know, so we can investigate a little bit further. But I mean, a black Ford Focus, late model, I mean, that's super general. That could literally be tens of thousands of cars.
Correct, right? So this is another factor is when you're looking at like, okay, there was information and this matches that information. You also have to think about, yeah, but how detailed was that information, right? You know, is this the kind of thing that like, you know, look out your window, like give it 10 minutes, you're going to see a late model black Ford Focus drive by because they're just all, you know, they're all over the place, like whatever. This is just like a common vehicle, right? If it were a super specific vehicle, right, that might be enough. And in particular, if you had something like, you know, a late model black Ford Focus, which had, you know, the license plate starts with J and it has a broken taillight. If you see that vehicle, that's a really good, you know, that's a really good match. Like you've matched very specifically. But late means newer. Am I wrong about that? Whatever. Anyway, I don't know.
No, somebody asked in the chat.
Oh, yeah.
Sorry.
It means older. Yeah, older vehicle. late model, old vehicle. So anyway, okay, good. So there's not probable cause to search this vehicle. So they could pull it over. They could ask for consent. They can try to ask some questions that might give rise to, is the person being nervous? Are they, whatever? They might develop probable cause, but they don't have it yet, right? They just need to do what they can do based on what they have.
I think it's also contextual too. Like if it's 3 o'clock in the morning and there's 3 cars on the road, and you're in close proximity to where it just happened, and then you see the black Focus.
Perfect.
That would be like a contextual thing. And then also what happened directly at the effect of the stop. Did somebody come up and was there any conversation, or did you just rip everybody out and start searching?
Absolutely. So I absolutely agree that, in particular, like how quickly the police, the proximity to the offense, right? I mean, if there's like a report of a burglary at a bank and there's a description of a car, and 30 seconds later, the police see a vehicle 2 blocks away, even though it's a general description, that's super close in time. That's probably enough, right? But if it was like, well, sometime in the last day or two, this happened, that's going to be too far away. It's too generic of a description. So it is contextual. It depends on all the facts and circumstances, which is part of what makes, it challenging to figure out exactly when the Fourth Amendment is or is not violated. But you have to use your kind of common sense and intuitions. Okay. Here's an example involving new technologies. So I don't actually know. I found this number in some recent news article, but I don't know if it's accurate or not, but I did find it in a news article. City of Cleveland has, I think, about 2,200 video cameras in public locations that the city operates. And in addition, they have this program that you all may be aware of, where if you have a private business, you can connect your camera to the police and give them access to it. And there are apparently 3,700 private businesses that are cameras that have agreed to connect to the real-time crime center. So this is a new technology. I mean, it's not that new, but it's newly deployed. Right now we have cameras all over the city of Cleveland. 5 years ago, there would have been a lot fewer than that. Right now there are more. So does that violate the Fourth Amendment if the police are operating this network of cameras? So Hamza says, right, no reasonable expectation of privacy in public. Good, right? In general, police are looking at you in public. It's allowed. But one thing to keep in mind from the Carpenter case is it's not just the technology, it's how the police are using the technology. So, for example, my question then goes on to say, if the CDP, and I don't think they do this, but if they did, if they started using facial recognition technology in connection with these public cameras to locate or track suspects, would that violate the Fourth Amendment? That's a little bit of a different question. Or you could say, let's say they said, you know what, we just want to keep track of Brandon Brown for a while. Let's just have somebody monitor him on these cameras, this network of cameras, over the next couple months, see what he's getting into. That starts looking very similar to what happened in Carpenter. You're using a different technology, right? Instead of a phone tracking, you're using this network of cameras, but you're accomplishing about the same thing. You're watching one person and you're monitoring their movements in public over a long period of time. That probably would violate the Fourth Amendment, right? If they did that. Again, I'm not suggesting they are. I don't think they are. But it's the network of cameras is not like legal or not legal in all scenarios. It's going to depend, based on this Carpenter analysis, how the police are using that technology. If they use it to say, you know what, there was an armed robbery on the corner of the street, let's see what cameras we got nearby and see what happened there. Almost certainly that is permitted, right? You're not really invading people's privacy by doing that. But you could also use that network of cameras in a different way that would be much more invading people's privacy. And then that might violate the Fourth Amendment. So now it's not just the cameras, do they violate the Fourth Amendment? It's how are they being used that is going to decide whether they do that or not. And again, the court's concern here is really, are the police using these new technologies in a way that are really going to allow them to see into really private, personal information about people? And if so, they maybe are going to need a warrant to do that. Doesn't mean they can't do it, but it might mean they need a warrant instead of just letting them use the cameras however they want. So, okay, that's another kind of technology example. All right, we're running pretty late on time here, so I think I'll wrap it up. But any final questions, I'm happy to respond.
I just have a quick question, reference my original one about the exceptions. So like emergency, would that still, is that,
Yeah,
that's still,
that's under this category of exigent circumstances.
okay.
Yeah,
So like you're looking for
emergencies.
somebody's medication or whatever on a stop and you come
Correct.
across, okay. And then what about like administrative? I don't know that we talked about administrative, like work desks or lockers at school.
Good. Administrative would fall under this category of special needs searches that I
Okay.
mentioned, but you're right. There are rules that are particular to especially like schools for students where they still have Fourth Amendment protections, but they have kind of less Fourth Amendment protection. So the rules are a little complicated there. Likewise for workplaces, it does get a little complicated, but it kind of depends on how the workplace is set up. So I have an office here at the law school. I'm at a public university, right? But it's really my office. I have a key to it. I mean, there is somebody else who could have a key, but other people don't come in here unless I allow them to. So if the police wanted to search this office, the deans of the law school would not have the authority to let them search my office. They would need to get a warrant or they would need my consent because this isn't the dean's office, it's my office, right? Even though it's owned by the public university. On the other hand, like I'm using a laptop. This is Cleveland State's laptop that I'm using right now. Our information technology people have access, I think, to be able to, I don't know what they have access to, who knows, right? But I'm sure they can monitor some things that are going on. The more access they have to my laptop, the more likely it is that they can just do that. And if the police want them to, they can do it. But if it's really just, so it's not an issue of like who owns it necessarily. It's an issue of how is it actually used? If you're using a shared workspace, anybody in that workspace can agree to let the police search the workspace. But if you have your own private office and nobody else can come in, even though it's your employer's office, it's your space for the time that you have it, that it's assigned to you. Okay, I think we're out of time. Am I right? Anything else?
Yeah, we're pretty close out of time. I know there are a couple questions in the chat. Does the Fourth Amendment apply during the invocation of the Insurrection Act?
That's a great question. I think the answer is I have no idea because, in general, the answer is probably yes. But if there genuinely is a national emergency, the courts tend to be pretty deferential in national security matters and give authority. But that's not the same thing as, let's just say, one president invoking the Insurrection Act in a context where it doesn't really seem necessary or warranted. They wouldn't necessarily automatically mean the Fourth Amendment doesn't apply here. I think it would depend on the particular facts.
All right. And then Art asks, what about banners that you consent on computers?
If you're consenting to, it depends what's going on there, right? I mean, if you agree to something, you're kind of assuming the risk. It does depend a little bit. I mean, when you agree to something on your computer, you may be agreeing to, typically that does not involve like, now I'm agreeing to just surveillance on my computer. I don't think that's typically what that means. And so it generally would not mean that you're now allowing just your computer to be under surveillance or something.
All right. Well, thank you very much. I mean, that was incredible. That was great, man. That was really informative. Thank you so much. This was everything that we needed and more. We also have the board has access to the slides, and I think OPS has the slides as well. Yeah, man.
Perfect.
If we need anything, we'll let you know. But thank you so much, man. We really appreciate it. This was great.
Thank you very much. Delighted to do it. Appreciate your work. Your work is really so critically important to making this all work. So thank you for all of your work. And, let me know if I can be of any assistance.
Hey, will do. Thank you. And thank you everybody from OPS and from the board for your participation as well. Okay. And with that, I think we have concluded our business for the day. So I will entertain a motion to adjourn.
Motion to adjourn.
We have a motion from Member Gadden.
I second that motion.
Seconded by Member Moore. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. All right, we are now adjourned at 3:01.